Hello, everyone, and thank you for joining us here today for this important discussion in this Google Hangout regarding patents and the patent legislation that's currently pending before Congress. My name is Gene Quinn, and I'm the founder and editor of IPWatchdog.com. And before we get going, I'd like to thank the Innovation Alliance and the Save the Inventor campaign for putting this together, providing the technology, and doing all of the logistics so we can have this important discussion. We have about 45 minutes here today to have this discussion, and I have a number of questions that I'm going to be asking. And we also would like to invite you all to ask questions as well. So what we've done is we've got a Twitter conversation going. You can reach us with your questions, just hashtag them Patents Matter. Again, that's Patents Matter, and we'll be having time for those Twitter questions that we get during this broadcast. So without further ado, let me introduce our distinguished guests here today. To my left, immediate left, is Senator Chris Coons, who is sponsor of some patent legislation that I suspect we'll get into talking about. And to his left is Congressman Tom Massie, who is an inventor and also very familiar and active in the legislation that's going on in the House. Not here today, but joining the conversation remotely is Louis Foreman, who is the CEO of Inventus and the CEO of Edison Nation, and he is an acclaimed inventor himself, an entrepreneur as well. So he'll be giving us that perspective here today. So with that introduction, let's just jump right to it since we don't have a whole lot of time. And my first question will be for you, Senator. It seems to me that when we're having this patent discussion, that this is one of maybe the only remaining bipartisan issues. And politics, in a strange way, doesn't seem to filter into the discussion so much. It's not an R versus a D. What it seems to me is it's more of a philosophical matter. Do you believe patents promote innovation, or do you philosophically believe patents inhibit innovation? That seems to be the line. So I thought maybe we could start off with that philosophical, and I think I know what you'll say, but I'm really curious. When that comes up, what do you tell people? You think it pro, or is it an inhibitor?
Well, Gene, you're right. This is one of the relatively few areas where there's not just strong bipartisan engagement, but very broad ranges. When you said that the congressman's to my left, he's actually not to my left. He's to my right. And if you look at who the co-sponsors are of the Strong Patent Act that I introduced in the Senate, Senator Vitter or Senator Cotton, for example, are not senators with whom I'm co-sponsoring a lot of other legislation. I do think that common across the advocates for a strong patent system in the House and the Senate is a profound belief that this constitutionally created and vital property right has to be defensible, that patent litigation has to remain capable of defending unique inventions, thus the Save the Inventor campaign. And those who are advancing the bills both in the House and the Senate that would change the patent litigation system are gravely concerned about what they view as so-called patent trolls. And in the only hearing that we had in the Senate Judiciary Committee to discuss the bill in the current Congress, they really focused in on abusive patent litigation practices that do exist and that are a problem. But more narrowly, in a more focused and targeted way that just deals with abusive litigation practices. And I happen to think that we already see strong movement in that direction, that the Supreme Court, the district courts, the ITC, the PTO have all taken actions that have begun to rein in some of the abusive patent litigation practices that were identified. I strongly value a strong patent system. And I think folks on the other side are focused, perhaps overly focused, on stopping what they see as the predations of so-called patent trolls. My concern, don't throw the baby out with the bathwater. Their concern, we absolutely have to act in order to rein in these abusive practices. And we've brought together strongly bipartisan teams of folks on both sides. The H.R. 9 and the patent reform bill in the Senate as well have strong bipartisan leadership. And the bill that I've introduced has strong bipartisan partnership. So you're right, this really isn't about party politics. This is about whether or not you think patents are essential, and being able to defend those patents are essential to the vibrancy of our innovation system.
Congressman, I'd like to ask you sort of that same question. Philosophically, would you say that patents promote innovation or that they inhibit innovation?
Well, you don't have to believe or not believe, right? We've got 250 years of history in this country of innovation, and we have the most innovation because we have the strongest patent system. The deal that our founding fathers gave us that was different from all the European models was what you create, you own, right? And the charge that our founding fathers gave us in Congress was to promote the useful arts and sciences by granting, for a limited period of time, the exclusive use of an inventor's works. So what we have to do is to decide within that charter, how do you promote useful arts and sciences, and for what period of time? There are some people, zero period of time is the correct period of time. That does not work. You know, I'm not a lawyer, I'm an engineer. I went to MIT and I studied electrical and mechanical engineering because I love creating. And right there in the laboratory and in the labs next to me, people were inventing stuff all of the time. And the great thing about being there in that hotbed at MIT is everybody wanted to start a company. And the way you started a company was you had to go get capital. And nobody was going to invest in you unless you had some intellectual property. So, you know, my startup that I spun out of MIT, my wife and I, we started right there in the married student housing dormitory, was licensed from MIT, from the technology licensing office. Then we went out and got venture capital. And they believed in us and they knew we had a chance, but we had this limited period of time to get a return on that investment before the invention became public domain. That's a great thing about patents. The deal you make with society is, I'm going to tell you everything about how to copy this idea. And when my exclusivity lapses, everybody in the world can have it.
And it's interesting that you say that because one of the things I think that's really misunderstood is just how long patents actually last. People, when you say limited time, I can just hear the people, the critics saying, but you know, it's 20 years, it's a generation, and when in fact most patents last about 4 years or 8 years because of the maintenance fees. So I wonder how that influences. Do either of you have any thoughts on that? How does that dynamic? Is part of what we're dealing with? Maybe people just don't really understand the patent system as much as I'd like them to.
I do think broadly a concern I have is that lots of folks who are engaged in this debate and this discussion don't understand the intersection between a strong patent system, being able to defend it effectively in court, and the ability to raise capital for a startup, as the congressman just described. It's that intersection and the key role that patent litigation plays in it that I worry about. It's not so much the length of the patent. I mean, it's a monopoly. That's what you're getting, is a government-sponsored monopoly. But the ability to actually defend that monopoly. If you've invented something special and you're agreeing to share that invention with the world, you have to be able to raise money. To raise money, to take it to scale, you have to be able to defend it. That means patent litigation has to be something you can possibly succeed at.
Right. Here's a big misperception about patents that I run up against here in Congress. Some people think they're to protect the big companies. And nothing could be further from the truth. I mean, the big companies have the advantage of size, they have the marketing channels, they've got the manufacturing, they've scaled up. It's the little guy that patents protect. The garage inventors who come up with things, and this was me in the beginning, and you go to trade shows and you got a little 4x8 table because that's all you can afford, and you show the world your brand new idea, and there's a buzz at the trade show. And your product would be copied within 6 months by all the big companies if you didn't have a patent. Patents are there to give the little guys a chance in that market.
Yeah. Okay. What I'd like to do is if we could just maybe pivot now from maybe the philosophical to maybe some more of the practical. There's pending reform in the House. There's pending reform in the Senate. Depending upon who you listen to, you get all kinds of different handicap odds on the various pieces of legislation. So maybe, Congressman, we'll start with you. How do you see things in the House now? Where do we stand? And if you care to, guess, what kind of percentage chance do you see reform having this year and maybe during this Congress?
Well, the bill that was brought forward in the House was H.R. 9, and frankly, it's a bad bill. It would have watered down our patent system through making it impossible to defend your patent. And so it would have affected all patents across all domains. But that's the legislation they tried to advance in the House. last Congress, they passed it in the House, but it didn't pass in the Senate. This Congress, when they brought it to the floor, slowed it down enough that we stopped it before the August recess. And frankly, I think we've stopped it for now in the House, but listen, this battle will go on for another 100 years. There will always be some of the big companies that are up here with a lot of money trying to weaken the patent system, and somebody's got to be here. Hopefully when I'm gone, there'll be people elected that will stand up for the little guy who doesn't have a lobbyist here to protect them and their intellectual property rights. But this battle will go on forever, but right now we've had a temporary victory in the House where we slowed down the bad patent legislation.
I think that's important because in the patent community, you learn about the 1952 Patent Act and how that changed everything and it streamlined everything, and maybe once every 50 years or so you get changes to the patent laws, maybe around the edges occasionally. But I think we really are in for a lot of push for reform on a yearly basis. Would you, Senator, do you think?
Well, Gene, what I referenced earlier, I'll just comment on again. There are real changes happening in the courts, in patent litigation, in the standards of review being applied, in the cost and the timeliness of discovery, for example. And I am very hopeful that those changes, given time to work, will reduce some of the intense pressure around patent litigation reform. But I would agree with the Congressman. This is going to keep coming back. There are very strong economic interests that are trying to weaken the patent litigation system. They see the economic consequences to them of patent litigation in a series of high-tech sectors, but it has a very different impact in pharma and bio and materials for universities, for venture capitalists, and those folks are opposed to fundamental and sweeping changes in patent litigation. So it's at an impasse at the moment. But it was, I mean, it's on the floor, it's come out of the committee, it's prime and ready for action. If several of the big companies that are competing over this come to an agreement, it could move to a vote very quickly. So
and that's in the Senate?
That's in the Senate. So my concern is that folks need to continue to invest time in outreach and education to Senate offices. I think as senators are hearing from their home state concerns, many of them are becoming balance that's struck in the bill. The sponsors are well-intentioned. They are trying to make what they view as a positive change. But I think once members take the time to really listen to the whole universe of folks whose lives are impacted, whose companies are affected by property rights, by intellectual property rights, they become less certain that this moving forward this soon after the AIA, when the whole post-grant review process is still relatively young, when there are steps being taken by courts to deal with some of these issues, they're less enthusiastic about racing ahead.
Yeah, and it's interesting, just listening to you talk, it dawned on me, something came to mind that hadn't really come to mind before, is historically the way that the patent system has evolved and changed over time is giving the courts a generation or two to figure out since the last change, and then Congress getting together and say, okay, well, we like this, we don't like that, and it's a much more thoughtful, considered approach rather than just a constant reform push.
It's just a few years since the AIA, which was the single biggest change in patent law in decades, and this new post-grant review process is still in its infancy, and I do think some reforms will eventually be called for, but I think it's pretty soon after AIA to make sweeping and fundamental reforms to all of patent litigation.
And I suspect you agree with that as well?
Yeah, absolutely. I mean, let's let this perturbation settle out and see what the positive and negative effects were of the America Invents Act, and before we go tweaking the system some more.
Right. Okay, this may be a good time to bring Louis into the conversation. Louis, can you hear me?
I am here, Gene. Thank you.
And I suspect you've been listening to the conversation, and what I'd like to bring you in on specifically is two things. One, the idea of raising capital and this idea that patents are not really for the big guy as much as they are for the little guy. I know you have been that little guy, you've been that startup, and now you have spent much of your career working with those kinds of startups. Right. So I'd like to get your perspective on that. And then the other thing is, from your businessman entrepreneur perspective, what concerns you about this patent reform?
Right. Well, thank you, Gene, and Congressman Massie and Senator Coons. Just hearing you speak about how important it is to protect the rights of independent inventors is very comforting. having a voice in this discussion is very important. You know, the independent inventor feels left out in the process. This is a battle of big companies trying to weaken the patent system and make it easier for them to just infringe on the rights of independent inventors. And the reality is that many of those companies, the irony is that they started with a patent. They were a startup that came up with a great idea. They raised capital around that great idea. And now that they're at the top of the mountain, they want to pull the ladder up so no one can compete with them. You know, I've been a serial entrepreneur since my college days, and all I've ever done is start businesses. I create jobs, and I create jobs around intellectual property. Our company here in Charlotte, we employ over 70 people who are inventing every single day. And those inventions are licensed to companies who then manufacture products and distribute products and create even more jobs. But what incentivizes us, what encourages us every day to go out there and do what we do is the ability to protect our inventions. There would be no incentive for us to take financial risk if we didn't have at least a period of time where others could not make, use, or sell what we've created. And that's why a strong patent system is essential to what we do. You know, Edison Nation is the largest community of inventors in the U.S. Over 150,000 independent inventors who have great ideas and need help bringing those ideas to market. And it's disheartening when we hear that Congress is thinking about making it harder to enforce those patents, because many of these inventors don't want to be entrepreneurs. They just want to try to license their inventions to other companies and be able to create some sort of monetary gain for their inventions. So, you know, when we go out and start businesses and we work with, you know, dozens and dozens of companies who come to us to start businesses, the first question that any investor asks is, what kind of intellectual property do you have? And without having a patent, you lose that core asset that an investor is really willing to invest in.
Thanks, Louis. And you know, I think we all know that patents are important to raise money. Those of us in the industry, I know that there are people who are skeptical of that on the outside, looking in the critics. But I mean, first, before I go on any further questions, do either of you have a reaction to what Louis has said, Congressman?
I do. Louis made a good point there about inventors. You know, I'm an inventor. In my case, I did start a company, but what I advise most inventors is find somebody who already produces something like your idea and see if you can get them to manufacture it and sell it. And then you can go invent the next thing, because that's what you're good at. And what's wrong with, one thing that's wrong with this patent reform legislation, they talk about patent trolls, and then they equate anybody who is a non-practicing entity to a patent troll. In other words, if you invent something, there's an assumption that you're doing something bad because you're not making the idea. And I say that notion that you have to, for instance, build the building if you're the architect, or that you have to build a cell phone company if you invent something for cell phones, that's as ridiculous, that notion, as telling an author he doesn't have a legitimate career unless he prints books and sells books. I mean, because authors are non-practicing entities too. You don't call authors trolls, right? But they're calling inventors trolls if that's what you want to do for a living. So that's one thing that troubles me about this legislation. It's delegitimizing the career that I came from, which is inventing.
And that's a very dangerous hair to be splitting, because most of the major tech corporations in the United States, the ones who are these giant patent holders, they don't make anything either. I mean, what they make in in certain situations and they sell is all made overseas. It's not made here in America.
By contract manufacturers, not
Correct.
by them directly.
Right.
Most of the household name technology companies we know are inventing, and then they are licensing, I mean, they're working in a range of relationships such that other companies are manufacturing, distributing, selling, and servicing the things that they're inventing. Yet they're at the very heart of the attack on the individual inventor as a so-called troll if what they choose to do is invent, license, invent, license, invent, license, and finance their ongoing invention through licensing phase. It's a distinction that's important to be very careful about. And I think that the choice of the term patent troll was intentional, was designed to sort of demonize those who are not manufacturing, when if you actually understand the field, it's far more complicated than that.
Yeah, and people always tell me, stop using the term patent troll for that very reason. And I say, absolutely not. I'm going to use the term patent troll as often as I possibly can, because I want you to think of the most hideous creature about ready to mug you from underneath this bridge, and then ask yourself, was that Thomas Edison? Are those the Hall of Fame inventors that the Patent Office inducts into the Hall of Fame every year? Are those the people who are the entrepreneurs that are creating jobs and growing the economy? And are the universities? And most people would look at all those people and say, no, that's what we want.
I asked my colleagues, what about the patent hobbits? Because I'm a patent hobbit, right? And you want to burn the forest down to go after the trolls. The hobbits are worried.
Oh, I like that. Now, I do have, before we get too far and we start to run out of time and we start taking Twitter questions, I have a political question for you two. And hopefully you'll be able to answer this. I don't think it's a loaded question. I'm not going to ask you about the other issues. But the one thing that worries me, or I don't know if worry is the right way to say it, but I wonder about, is I know both of you are very passionate on this issue. Patents, I've always described it as, it's not an issue that is going to drive people to the ballot box on election day. So I wonder, what's that?
Sadly, you're right.
Yeah. So I wonder, when you go back to your districts and you have your town hall meetings and you meet with people or they come and visit you, and they ask you, why are you spending so much time on this? Why does this matter to me? What do you tell them?
Well, go ahead, Senator.
Two things. I'm from Delaware, so we have a remarkable concentration of patent holders and inventors and entrepreneurs in Delaware.
So they get it?
Some, not everybody. But the neighborhood I grew up in, I think 10 out of 14 heads of household were DuPont engineers. And several of them were patent holders. My Boy Scout troop leader, my next door neighbor were inventors and patent holders. But I agree with you that broadly it's an uncommon concept. I must say Everyday Edison has done a great job of helping people understand it. Shark Tank has helped people understand it, popularizing the idea of the importance of having a patent in order to attract capital. What I tend to say to folks is there anyone in your family or anyone who you care about who's currently suffering from, and list a whole series of disease states, whether it's Alzheimer's or ALS, whether it's diabetes or it's Parkinson's disease, and say, I have met with the CEOs of small early stage startup bio and pharma companies who are investing huge amounts of money in bringing to market cures or treatments or medical devices that are going to help with those conditions. And without their ability to defend the patents that they've invested so much in developing, they're not going to be able to bring that to market. These things don't happen magically. They happen through private innovation and invention.
Or even worse, in some of these cases, they may be able to still take it to market, but they're not going to disclose that information. Right. So they're going to keep it as a trade secret and really prevent the next generation of giants from standing on the shoulders of the giants who've come before them. And that worries me.
Well, when I go back to my district, I see a lot of kids and a lot of parents involved in these STEM programs, like the America First program or the Lego robotics programs, and they're all competing. And parents would like for their kids, a lot of parents would like for their kids to grow up to be engineers. And I say, look, if we take away the measures of achievement, patents are like Heisman trophies or whatever, for nerds of us, okay? They're measures of personal accomplishment in your field. If you take those away and then you deprive the heroes in that field of an income, why should you expect your children to pursue that study? So back to STEM, and so much effort has been spent on trying to revitalize our country and our education system on STEM. And I say, look, let's don't disincentivize our children from becoming inventors, and that's what we would do if we pass bad patent legislation.
Well, with that segue, let me ask you, we talked in generalities a lot so far, but what are the things that most concern you? Because it seems that, well, maybe I should ask you first. Would you both agree that it's the Innovation Act, H.R. 9 in the House, and the Patent Act, I think it's Senate 1137, those are the two primary bills at the moment? Okay. In those pieces of legislation, what are the issues that worry you the most? Senator?
There's a whole series of changes to the practice of patent litigation, worse in H.R. 9 than in the Senate bill, but just broadly speaking, there's a whole series of things that do that affect discovery, that affect fee shifting, that affect standards of review, that I think will make it much harder for the genuine individual inventor to both raise capital and then to be able to succeed in scaling. There are alternative bills, the Strong Patent Act that I've introduced that also includes the Troll Act within it, that would strengthen the patent system, attacking PTO fee diversion, for example, that would strengthen the post-grant review proceedings, and would also go after abusive demand letters. But it would only make very narrow and targeted changes to patent litigation to go after what is genuinely abusive behavior, and then strengthen the patent system as a whole.
Yeah. Now, before I ask you about the Innovation Act, let me follow up there. I mean, what are the odds that the Strong Patent Act, which is really in the Troll Act, are very, very similar? Right. What are the odds that in order to accomplish something, that they will at some point during this Congress become the primary vehicle?
I'd be thrilled.
Yeah.
I think the odds that will sort of leapfrog the alternative. It hasn't come through committee, hasn't gotten a hearing in committee, and so just by regular order, I think the odds are fairly small, because it's a fundamentally different approach to dealing with the problem of abusive demand letters. It's a much narrower, more targeted approach, and it strengthens the patent system as a whole. I think it would be a more measured, balanced, and responsible way to deal with what are some challenges in patent litigation and the cost and length of discovery. But I think right now, the sponsors of the current legislation that's had a hearing, that's moved to the floor, are pretty dug in on moving with their approach.
Okay. And Congressman, the Innovation Act, what troubles you?
One thing is it's going to scare away investment, and it's going to make universities less likely to want to license their ideas. And here's why. This is a bipartisan, the Democrats and Republicans on both sides of this H.R. 9, the bad legislation. Well, one of the ways it's been sold to Republicans is, hey, this is the tort reform you're looking for. There's tort reform in this. But the problem is, it's got loser pays, and if you go into a patent battle, which sounds good until you realize the little guy has got more to lose than the big guy when you go into that battle. But the other problem is they say, well, we're not just going to go after the loser, we're going to go after his investors and anybody that stands to make money from this or benefit. Guess what? That includes universities. And so now patents would become a liability. Licensing their ideas would become a liability because they could be subject to being enjoined into a lawsuit and have to pay. So that's going to scare away not just investors, but the universities. Now, Lewis said something, too, a while ago, that a patent is a right to make, use, or sell. Okay, those three things, if you're, to exclude somebody from doing that. It doesn't, until you start thinking about patents, you don't realize why you have to cover all three bases: make, use, and sell, right? But what this bill tries to do, the well-intentioned folks says, well, we want to protect the innocent consumer who buys a product at a consumer electronics store, takes it home, and then gets a letter that they're being sued. Well, okay, that's noble enough, but there are other customers too. A big cell phone company is a customer to a chip manufacturer, and so the very provisions they're putting in there to ostensibly to protect little guys actually protect the big guys because they're customers too.
Yeah.
So they're
so-called customer state provision.
Yeah, and it strikes me that is a very noble thing to try and solve, but that's not how the legislation is written. It really needs a fly swatter, not the elephant shotgun, and that seems like the approach that they've been taking is just to pull out an elephant shotgun to kill the mosquito.
Or to taking a lawnmower to your flower bed to cut the weeds.
Right.
I mean, you could cut everything down.
Yeah, I like that one. Now, Lewis, I'd like to get you back in on this here. On the heels of this, and if you want to comment on the legislation specifics, that'd be great. But I specifically, before we turn to the Twitter questions, I want to ask you, what has the patent system meant for you?
Well, personally, Gene, the patent system has meant jobs and opportunity, not only for us, but for the inventors that we come across every single day. Congressman Massie brought up a great point about the customer stay provisions. Many of the products that we get involved in are consumer products that can be knocked off overseas very easily. trying to shut down a Chinese factory that's infringing on your patent is tough. And if you weaken the patent and make it harder with the customer stay provision, it would be impossible. Because even if you could target that one infringing factory, they'll just move the molds to another factory, and then the process begins over and over again. Anything that makes it harder for an inventor to have certainty to his property right is going to reduce the incentive for inventing in the first place. Everyone has great ideas, but only about 13% of the US working population are entrepreneurs. That means 87% are risk averse. And those are the inventors who come up with great ideas that they want to license to somebody else. If you make it difficult to license by labeling those inventors as patent trolls, then you deprive society of those amazing inventions.
That is a perfect segue here. I don't know whether you're reading the Twitter questions, but we have some Twitter questions about patent trolls. The one that I'd like to get to first on the heels of what you just said, Louis, is what reforms would you support that could discourage the trolls but would not amount to carpet bombing all patents? That's from Twitter. Senator?
Well, there's a number of provisions in the Strong Patent Act that are similar to what's in the Troll Act. First is raising the standard of pleading, which I believe is on target now to happen. There are rule changes that have been adopted by the Federal Judicial Conference. So getting rid of the form pleading standard is something that is already underway that has historically made it just too easy to file quickly and without having to plead in specificity. Second, there's ways to go after using the ITC to go after demand letters and to go after folks who are the Trade Commission, excuse me, to go after folks who are practicing abusive practices. And there are some other provisions, both in my bill and in the Troll Act, that I think would make significant progress. The larger point I want to make, and this I'll borrow the metaphor of not using the lawnmower to cut down the wildflowers to go after the weeds.
I'm going to misappropriate that one myself.
Is that the fundamental changes to patent litigation that are in the Patent Act apply to all patent litigation. There's no sort of gate that narrows it only to those who have pursued litigation more than 25 times, or where that patent has never been practiced, or where there's some other indicia that it's an actual practicing company of any kind. In the markup on the Patent Act in the Senate Judiciary Committee, I offered a half dozen amendments that would have narrowed its impact, and they were all rejected by pretty broad margins, showing that I don't think that was a narrow or targeted approach that they were going after at all.
Yeah. Well, another question that we have from Twitter is, and I think this goes to the Strong Patent Act, what can we do about fixing the different invalidity standards between IPR and district court litigation? Because it seems to me that really bothers a lot of people.
Well, it depends.
It depends on who you are, I suppose.
Right. It bothers you if you have a company that depends upon strong patents to now have a process that has a very high kill rate, where 3/4 of the patents that are being challenged are being invalidated, and where the standard of review is significantly lower than it is at the district court. It is achieving, I think, the objective of reviewing a patent quickly and at relatively low cost compared to district court litigation, but it isn't giving this vested property right an appropriate standard of review. So, I mean, I think the clear and convincing evidence standard in the district court ought to be the same that's being used in post-grant review, because you're taking away a vested property right.
Yeah, and that worries me a lot, because it seems, I mean, anytime you have different standards, I think it leads to the possibility of gaming the system, which I thought we were trying to get away from in this situation. We have another question here at Twitter that I'd like to get to, and Louis, I'm going to ask you to maybe follow up on this one as well. How can we protect small companies that cannot afford to defend the patents that they've received? Is there any way, because the patent system is supposed to incentivize people to take a risk, and right now it seems through some judicial decisions and legislation and the constant drumbeat of reform, the incentive structure is on the brink of collapse. That's my opinion.
I mean, I think moving to a loser pays system, there are recent Supreme Court decisions that strengthen the standards by which a district court can award fees to a successful litigant. One of the key features of H.R. 9, the congressman talked about, is a loser pays approach that I think is very detrimental to helping a small startup company attract and retain the capital to expand. But I'd be interested in what Lewis has to say.
Yeah, Lewis, what as a startup entrepreneur and inventor would you like to see happen? Is there any way that the system could help you guys?
Sure. I think, Gene, if you have a strong patent, and if it's universally known that patents are a strong property right, that's an asset. And that asset you can borrow against, you can raise capital against that asset, and it gives you the motivation and the incentive to take risk and build a company around it. When there's uncertainty as to the ownership or the value or the defendability of that core asset, that's when you run into problems. And so if you have a strong patent and everyone knows you've got a strong patent, then defending that strong patent, you'd bet everything that you've got to defend it because you know that deep down you own that property right. But if you erode the value of a patent and make it harder to enforce, it makes it really difficult to make that decision if you're going to spend money to defend it.
Yeah. Okay. Well, let's see if we can get to one more Twitter question in the time that we have here. And it's a basic question, and we probably write a thesis on this if we had to. But I think it's a good question. Is what's wrong with the existing laws, and why do we really need to be doing anything at this point?
Well, I don't think we need to change the laws that govern the current patent litigation system. As I've said before, I think the Federal Trade Commission, the FTC, can and should be strengthened to take action against those who are genuinely engaging in abusive practices. I think that the pleading standards can be raised, and that's underway. That's something that's being done judicially. The District Court of Delaware, which is one of the busiest in patent litigation in the country, the judges have taken notice of real concern over the cost and length of discovery in patent cases, so they're taking action around it. Supreme Court cases have moved towards a more balanced approach to the risks undertaken in patent litigation. All of those are, I think, moving in the right direction to deal with what have been some genuine concerns about abusive litigation practices. Changing the rest of the structure of how patents are awarded and how patents are litigated, I think is just overreach, frankly. And so I don't think there is. I think if we could look back at today from 5 years from now, we would not see a compelling case for the Patent Act or for H.R. 9, because I think the trajectory in terms of dealing with these issues is already well underway.
Yeah, and I would agree with that. And one of the things I think that fundamentally we have to always remember is we're dealing with a one-size-fits-all patent system. There's not a patent system for biopharma where they absolutely need strong rights on a very limited number of innovations. In the tech industry, it's going to apply across the board. And my sense of the fee-shifting rules in the various bills that are pending is they are quite different from the Supreme Court rule. They're much more aggressive, and it's much aimed towards the defendant, not towards the patent owner, whereas the Supreme Court's decisions would really apply across the board. If you engaged in certain activity that was inappropriate during litigation and you lost, you would have to pay, whereas the legislation really is patent owner-centric, which doesn't strike me as very fair. Lewis, do you have a feeling on that?
Yeah, I would agree with you, Gene. You know, when you go to a fee-shifting model, it really allows the other side to game the system. If you're a small independent inventor going up against a really large corporation, they can intimidate you by saying, look, we'll spend 10 times what you're going to spend to beat you, and we'll find a way to beat you, and you're going to be on the hook for not only your attorney's fees, but also for ours. That intimidation could cause the inventor to settle at a much lower rate or drop the litigation altogether and not be able to defend their patent rights. And so I think it's just a bad system for small inventors.
I agree. Now, we spent this 45 minutes, it went quick, but I'd like to ask you, Senator, if you have any thoughts, if there's one thing that you would like people to remember from this conversation, what would that be?
It's that the whole system of invention and innovation that has been fundamental to America's economic strength and vibrancy is at risk if we move forward with overbroad, ill-considered legislation that would change the rules. It wouldn't just go after so-called patent trolls. It would go after a very wide range of industrial sectors, and it would have very harmful impacts on folks like Congressman Massie, who is himself a successful patent holder, inventor, patent holder, and entrepreneur, like the folks that Lewis works so closely with. If the folks who are watching or have participated haven't studied these bills closely, they need to realize there's a real chance they'll move forward, and if they move forward, they'll do lasting harm to our whole national system of innovation.
Okay, well, thank you. And for those of you who are watching the Hangout, I just want to let you know, we haven't ignored Congressman Massie here. He was called away a few minutes ago on other business. So we appreciate him taking the time to join us today. Senator, thank you so much for joining us. Lewis, thank you for joining us remotely. We really appreciate that. We appreciate all of you joining the conversation as well. This video Hangout is going to become available at the Save the Inventor website. That's www.savetheinventor.com. And I encourage everybody to watch that, disseminate it, please tweet about it. The conversation will continue after this on Twitter with the hashtag Patents Matter. Again, thank you very much for joining us, and I appreciate your time, Senator.
Thank you. Great to be with you. Thank you, Lewis.
Thank you.
Thanks, Lewis.